Hello, everyone. This is Stacy Lake, and this is my July 14th presentation for Let's Talk Jackson regarding the Jackson County trial, day number 3. Before we get started with these witness testimonies, there were a multitude of issues that happened before the trial started that I wanted to cover. And so we are first going to start with there was a motion for sanctions being heard. And this motion for sanctions actually got quite a bit of media coverage. The media coverage was surrounding the fact that now the state AG, Andrew Bailey, has to be deposed due to this motion for sanctions. Now, before the trial started, and actually, I need to put this disclaimer first. Remember, everything that I say here today are from my notes. I am not a court reporter. These are my transcriptions. I'm not here to offer anyone any legal advice, and everything that I say here today are solely my legal opinions. And even though I took a multitude of notes and I tried my best to make accurate notes, my notes are prone to error. So please do not take everything that I say as absolute fact. This is just my interpretation of what was said at the time. Now, before the trial actually started, there were a multitude of motions being heard. First, the defendants, the Jackson County government, heard a motion to exclude Preston Smith's testimony, which I believe was denied because Preston Smith later on testified. But the more serious motion, and the one that we're going to start off with today, is the motions for sanctions that was being heard. Now, during this, it was an oral argument because the county defendants, and when I'm talking about county defendants, I mean the Jackson County government, their attorneys were arguing. They presented this motion like in the wee hours of the night, and so they were arguing the oral motion on that day. And so the county basically stated that Jackson County legislator Sean Smith and the Missouri State Attorney General Andrew Bailey went into a closed-door meeting. And the county is basically stating that this happened in April, and we're going to get more in depth into that specific interaction. The county defendants also alleged that the 2 depositions that were previously taken about these attorney-client privilege or potential violations were in conflict with each other, because in one deposition, and if you don't know what a deposition is basically you can think of it as a meeting between a witness or a plaintiff or a defendant where the other side has the opportunity to ask any question to the other person. And so when they were having this meeting with the person that represents the AG's office on these alleged communications, they stated that one person said that they talked about this case, and then there was another statement stating that they didn't talk about this case, and so that they needed to have the deposition of Andrew Bailey in order to determine whether or not attorney-client privilege was violated. Now, the attorney-client privilege basically turns upon the fact that Jackson County legislator Sean Smith is a defendant in this case, and that if he went to the Missouri state of Missouri AG's office and told them what the Jackson County defendants were going to do during trial, that would violate the Missouri rules of professional conduct that we have for attorneys. It would be giving improper attorney, or it would be providing improper attorney-client privileged information to the other side, which would be unfair to the Jackson County defendants. Now, the judge basically asked the county defendants to read the deposition testimony to the court, and the testimony read in part What question? What was the nature of the contact? Answer. The AG stated that they talked about the assessment, but he did not know who talked about it and who was in the room. All the Attorney General remembers is that Sean Smith and campaign staff was in the room. The Attorney General also stated that Sean Smith said that the Jackson County assessment case was important, and that was the essence of the communications that he had with Sean Smith. Also, the Attorney General, they alleged, wanted Sean Smith and the Attorney General to do a joint media statement, as well as another media rollout regarding the Jackson County property assessment, but there was no follow-up on that activity. The county attorneys then started to argue that the conversation surrounding the attorney general and Sean Smith was too vague, and that the ex parte contacts have placed the county in an unfair spot and violated the attorney-client privilege. What they're basically saying is that the communications that they know of were too vague and that they were unsure as to whether or not these communications occurred. And I'm going to also state this too. My internet has been going really slow recently, so you might see a little bit of my visual being choppy, but I know my audio is going through, and that's the most important part. So just bear with me. So after the state presented their argumentation, the state AG's office then did a rebuttal, and they said that Sean Smith was an individual. He did not have supervision. He did not, like the Jackson County government does not have supervision over him, or he does not have supervision over the Jackson County government. He does not have direct or control over the county attorneys. And that since the county attorneys did not argue this in this motion, that it should be denied because they were supposed to argue this in the motion. Additionally, the state attorney general's attorneys argued that no attorney-client communications were made and that they turned over all communications. Now, when the attorney general's office made this argument, the judge disagreed with the attorney general's office and stated that she sees that there was a violation of the attorney-client privilege due to Sean Smith's communications with the AG's office, and that the judge then ordered the state attorney general's office to produce the state attorney general's attorney's notes over the meeting, and she then further ordered the deposition of the state attorney general, Andrew Bailey, over his communications with Sean Smith. And we're going to go over this order right now. So this is the actual order on sanctions that the judge wrote, and which you can find. This is a public copy that is filed on CaseNet. So if you're interested in reading about it, please do. But in summation, the within the order on sanctions, the judge found that there were two meetings regarding Jackson County legislator Sean Smith and the Missouri Attorney General's office. One was regarding a meeting with Andrew Bailey in person that was on or about April 27th, 2024. And one was with the Attorney General Counsel, so their actual attorney, that was done virtually on May 29th, 2024. The Jackson County defendants argued that the plaintiff counsel has had ex parte contacts. Now, what ex parte contacts means is contacts that are made outside of the courthouse without all parties present. So the Jackson County defendants argued that plaintiff's counsel has had ex parte contacts that violate Missouri Supreme Court Rule 4-4.2, which provides, and this is what the rule states: in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or by court order. So this is the actual rule, but I want to pull up. This is the actual comment that the judge focuses on in her order. So the Supreme Court made a comment on this Rule 4-4.2 in order to make her finding that the state attorney's general office did violate this rule. And this comment basically states, in the case of a represented organization, Rule 4-4.2 prohibits communications with a constituent of the organization who supervises, directs, or regularly consults with the organization's lawyer concerning the matter or has the authority to obligate the organization with respect to the matter, or whose act or omission in connection with the matter may be imputed to the organization for purposes of civil or criminal liability. In communicating with a current or former constituent of an organization, a lawyer must not use methods of obtaining evidence that violates the legal rights of the organization. In the judge's order, she basically cites a test that she used that basically states that this comment, the comment that I read before, is a functional approach designed to be sensitive to the practical considerations of the real world, and that the court found that Jackson County legislator Sean Smith first regularly consulted with the county lawyers regarding issues surrounding with the Jackson County trial. 2, has the authority to obligate the county with respect to those matters by way of resolutions and ordinances. And 3, Sean Smith's actions or admissions in connections with those matters may be imputed to the county for purposes of this lawsuit. So they basically stated that Sean Smith should have never had these communications with the Attorney General's office, and certainly not with the Attorney General's counsel. So because of that, the court granted the motion for sanctions and imposed sanctions against the state AG's office. In the order, first, the judge ordered the plaintiffs to provide any notes or recordings of the virtual meeting with Sean Smith for an in-camera review, and 2, ordered that the Jackson County government has the opportunity to depose the Attorney General, Andrew Bailey. However, his deposition has to be limited to 1, conversations and communications made after the case was filed between Andrew Bailey and Sean Smith regarding the Jackson County trial, and 2, that Andrew Bailey shall address the nature of contacts, who was present for the contacts, and what was discussed during those contacts. Now, when the oral order was issued, the state attorney general's office provided the judge the notes that they took during the virtual meeting. And in this order, the judge found that there was, with just the attorney general's counsel notes, that there was no attorney-client privilege information obtained in those notes. However, the Jackson County government still will be able to take the deposition of Andrew Bailey. That's within the scope of those 2 limitations that I told you about. Basically, conversations that were made with Sean Smith regarding the Jackson County trial, and 2, the nature of contacts of basically who was within this meeting during the time. So next, there were communications received by the judge. Now, what are communications received by the judge? So when any trial is going on and the judge receives an email from an outsider about the trial, the judge has to publicize that communication on CaseNet. They have to show what that communication was publicly. That is why, and I'm just telling everyone, If you send an email to the judge will make that email public. And in this case, 2 emails were sent. And we're going to get to that right now. The first email that was sent was from a lady named Stacy Cronhart. And in this email communication, she basically, I'm going to read this letter to you. And this is a cautionary tale. Please, if you can get anything from this, do not send any communications to the judge, because if you do, it will be publicized like this. But she wrote to the judge on July 6, 2024, and the subject was Jackson County Personal Tax Hearing, Sean Smith. And it reads, Saturday greetings, Judge Krauser. I'm writing to you as an over 21-year resident of Jackson County. I grew up near the Missouri River in historic St. Charles, Missouri, attended the University of Missouri-Columbia, worked for 2 amazing hospitals in Columbia before settling into the KC Metro in 2002 to work at North Kansas City Hospital to this day. My husband and I purchased a home in Lee Summit, Missouri in 2003, and our 2 children have been fortunate to have been a part of the Lee Summit School District. My reason for reaching out is in reference to the current Jackson County legislator and 2024 Missouri congressional candidate, Sean Smith. Legislator Smith recently spoke at a group where he regularly frequents and is a member, We the People of Jackson County. At the July meeting on July 1st, 2024, posted on their public YouTube channel, Sean spoke about the topic of personal property tax, following an admission that he was forbade to do so. Reference 130 of the meeting. His references of topic were general while being partisan. Everyone is most certainly entitled to their opinion, but this was a violation of order. I am not a tattler. While I have more than significant issues in this group, issues with this group and their followers threatening comments regarding my 2023 BOE campaign, I am concerned about the blatant skirting of regulation in this situation. Thank you for your time and consideration. Kindly, Stacy Cronhart. And she provided a link to this alleged meeting, which was it's a YouTube video recording of this meeting where Sean Smith is talking about in part about the 2023 property tax assessments. Now, as I stated beforehand, this is not to give any legal advice. I'm not trying to provide a legal opinion, but right now, Sean Smith is still a sworn witness. He has not been retired. As if you've been following me, he was brought to the stand on day 2, which was June 29th. Okay. So he hasn't been released from the stand yet. So he's still a sworn witness. He cannot speak about this case at all. If there's anything I can impart to Sean Smith would be, please, to not talk about this case until you are finished with this trial, until the judge, the county defendants, and the state AG excuses you from the witness stand. Anything you say will and can be used against you in the court of law. And as you see here, a citizen wrote to the judge about this communication. The next communication that was submitted was a communication by a person named Karen Jones. And this was sent to the court on July 10th, 2024. And basically it says, hi. In the article, homeowners called Jackson County assessor liar following testimony in tax assessment trial, KCTV5 reported, and then she copy and paste what KCTV5 said. And then she continues, I can personally document that this was a lie. I won my tax appeal because a tax assessor included a garage that was torn down due to code enforcement process at least 2 years before I bought the property in 2012. Had they done the physical inspection they were supposed to have done, the assessor would have seen that the garage was gone. My appeal took less than 5 minutes and lowered my tax height from a 155% increase to just $35.40 more than my tax bill in 2022, if that helps Karen Jones. As I stated before, this is not going to help any side of the case because the judge cannot take this into evidence. The state did not present this into evidence. I believe Karen Jones was not a testifying witness. And so any communications that you send to the judge will be, 1, publicized, and 2, disregarded from the court, okay? So please do not send communications to the judge. Next, there was a motion for joinder, and this motion for joinder, so a motion for joinder is a fancy way to say it's a motion to join. There was a person named Thomas Caesar Popson, and he requested the judge to add him as a party. Now, Thomas Caesar Popson is a private citizen, and he's actually representing himself, and he filed this motion to see if he could be added as a plaintiff in this trial. And of course, the judge denied this motion. And as I said, the judge denied it on several grounds because, as I stated before in other lives, only the state AG's office right now can litigate the claims that they're litigating against the Jackson County government. And that's why this is the best shot that we have in order to overturn the 2023 property tax assessment, because only the state AG's office is authorized to file a case against the Jackson County government without having to go through the steps. Now, I don't know what Thomas Caesar Popson's story is with his properties, but as I stated earlier, in order for a private citizen to have the right to file a civil case against the Jackson County government, they first have to go through their administrative remedy process, which is going through the BOE, then the state tax commission. And once the state tax commission's issues a ruling, they can then take it up with the Jackson County Circuit Court. If that hasn't happened yet, then your case hasn't exhausted the administrative remedies and it will be dismissed. And so the judge denied this motion. But as I stated before, this person who filed this was a pro se plaintiff, meaning he was not represented by an attorney. And I believe that if he was represented by an attorney, they would have told him the same thing I'm telling to you. So after that was done, Preston Smith was called to the stand. Now, Preston Smith is a data analyst expert in this case. He has a degree in public administration and statistics and over 30 years of experience and has worked with multiple cities in the past. He also has a master's in quantitative analysis and has extensive experience in Excel and data analysis, and has experience with working with DST for 8 years and doing multiple audits with cities. Currently, Preston Smith runs his own business and works with school districts to do geographical analysis and gather large amount of data for forecasts and projections to predict how many students will be in the district in the future. Many of you guys know, but Preston Smith was also a Board of Equalization member for 14 years. Preston Smith stated that he would listen to the appeals and then do research on the parcels in order to make his decision. Now, Preston Smith is testifying first as an expert witness in data analysis. Okay, so he's basically going to be looking at the data and giving his own opinion on how the county used their data. And he's testifying to whether the data supports that physical inspections were completed and to the accuracy of the data that was used. So Preston Smith first started his testimony by going through his relationship with Gail McCain Beatty. Preston Smith stated that in 2019, he had a meeting that was very odd with her. He stated that he received data from Angie Racono, who Angie Racono is a reporter from KCTV5, that showed that the 2019 assessment was incorrect. Now, when this happened, the other side started to object because apparently the court has told the other side not to mention anything about the 2019 property tax assessment. While, you know, people can argue one way or another if that's fair or not, that's still the rules of the court. So they were not able to bring up any information about 2019 property tax assessment. But he then started to go through his slides. And luckily, I have his slides here. So the first, well, and when I say first, this is like my notes that I took. So first, he was talking about slide number 4. Preston Smith stated, and he's referring to slide number 4, that in 2023, 94% of residential properties increased in value. And Preston Smith stated that there were multiple errors. And when he's talking about one of the errors that he noticed, he was talking about the parcels that had the number, the assessment valuation number of $356,270. Preston Smith stated that there were some properties in the neighborhood that sold clearly above $600,000, but were assessed for the $356,000 value. Now, if you look at the first line of this slide number 4, you can see the slide that the information that he's referring to. Preston Smith also states that there were properties sold well below $300,000 and given the same number value. Preston Smith stated that the number of $356,270 was used 573 times in this assessment. So Preston Smith then focused on the valuations between the wealthy and poor neighborhoods. Preston Smith stated that the $256,270 value was used more times in poor neighborhoods. Preston Smith also talked about the residual impact of properties being sold at high values in neighborhoods affecting other properties. Now, this point that Preston brought up was really interesting because it's true. There's been a multitude of neighborhoods where a developer would come in, buy a property, then renovate the property, and then sell that property for way above what the normal value of that house is. So say if you live in a historic neighborhood, like for instance, I live in Hyde Park, and in Hyde Park, the average house is over 100 years old. So there's a lot of houses that haven't been renovated in decades. And so what Preston is basically saying that it would be unfair for a house's value to increase because a neighbor's house that had renovations and then were sold for a higher value, that would then dictate that the house next to it would have even a greater value than the year before. The state attorney general's office then started playing a video of Gail McCain Beatty's public legislature testimony. And so this is the start of the state attorney general's office using videos in order to make Gail McCain Beatty's testimony contradict itself. So the testimony basically was talking about how Gail notified the Jackson County legislature about the errors in the 2023 property tax assessment. In the video, Gail was admitting about the errors in the 2023 property tax assessment and admitted that she manipulated the data. Gail also explained how she entered the data into the spreadsheet wrong and that there were no checks and balances in the system. This was an actual video recording of Gail McCain Beatty stating this. Preston Smith then continued his testimony and stated that Gail's process had many errors. First, he stated that there should have been other people looking at the data to make sure that the system's data was correct. And then Preston Smith stated that the assessor department has over 100 employees working for her and that it was wrong that she did not have any checks and balances to make sure that the data she entered was correct. Preston Smith then stated that he agreed that the assessor's job of assessing the property values is hard. Preston Smith then talked about how he requested, he basically made a sunshine law request that would only show parcels that had an increased value of over 50%. And Preston Smith stated that he received the information and found a multitude of errors in those property values that increased by over 50%. Preston Smith stated that he received this data on June 1st and found these errors, which we are going to get into. Preston Smith stated that he called the assessment department and pleaded with the department to look at the data to correct the errors before the impact notices were sent out. And remember, the impact notices are the official 2023 reassessment notices that we were supposed to receive before June 15th. So Preston Smith then shows these following slides to the court. So Preston Smith stated that the assessment department changed some of the data on July 9th. And when he's showing this slide. And so this slide right here is a nursing home that was valued in 2021 for $2.1 million. But in 2023, it was valued at $47 million. Okay, so just remember that this was an error that Preston found on before the June 15th 2023 official, when they were sending out all the notices. And this is when, based on the information he received on June 1st. Then on this slide, Preston Smith stated that there were hundreds of properties that were like this. And this is going through the properties that he was talking about. He states that there was an apartment complex that was valued at $21 million in 2021, whose value increased to over $200 million in 2023. Preston Smith stated that this showed that this chart that he's showing right now on this slide gave him great concern because these were errors that he found on June 1st, 2023. The assessment department responded to Preston Smith and told him that they would correct these errors. Preston Smith stated that this showed that this was not a small problem with the data, but a larger problem with the system. Preston Smith stated that he did not believe that the assessment department didn't do any effort to make Preston Smith stated that he didn't believe that the assessment department did any effort to make sure that address changes were noted, and he stated that over 17,000 addresses were affected. Now, then Preston talks about Frank White. And this is the infamous slide. So first, Preston Smith starts talking about properties that are owned by public officials. He basically showed that Gail McCain Beatty's property assessed value increased by 13.6%, and Frank White's assessed value increased by 7% in 2023. And so then, in this slide that I'm bringing up is in this picture, you see the red circle. That is Frank White's house. And so he basically took the information of all the values in Frank White's neighborhood that were increased, like the houses that were increased, and compared them with each other. So Preston Smith basically stated that Frank White's property was increased by 7%, but his neighbors' properties were increased by over 41%. Then he showed this slide 18. Preston Smith was talking about properties. Okay, yeah, this one was crazy. So Preston Smith then starts talking about properties that did not have any property taxes assessed. These are properties that kind of fall out of the system. They're basically like, for instance, if like say you have a street that has a stop sign, right? That slither of land isn't going to be assessed for properties, right? But he was talking about errors in the system where you had full houses on parcels that basically were bleeped out of the system and were not properly assessed. And this is one of the examples that he showed. Preston Smith said that there were over 375 parcels that he found of actual houses that did not have any property tax assessed to those parcels. Now, this property that he's showing is a Lee Summit property that was on the tax rolls for 2022 for $200,000, but was taken off of the property tax roll in 2023. And therefore, this property that I'm showing you right here was not assessed for any taxes. Now, in this slide, Preston Smith stated that this Lee Summit property that I showed in this slide right here, he further says that it was inspected twice by the assessment department. Preston Smith then stated that the field inspection and the other inspector, so the field inspection inspector went out there and the other inspector went out there, but that they were not connected, like their data did not connect with each other. And he stated that even though this property was inspected twice, it was still taken off of the rolls. So then Preston talks about how he basically picked a random street in Jackson County in order to do an analysis to see if the data was correct. And so he picked this street here. So then he basically analyzed the street. And in this analysis, these are the colors that showed the levels of the increases. Preston Smith testified that the standard deviation was 3 times that of 2021. So that means that the difference in the different property values were 3 times larger than it was in 2021. So we're still on this street, and Preston Smith is specifically talking about the large deviations of the property values on this one street that he selected. And so on this property, right, you can see that this house here on the left was valued by the Jackson County government for $63,790. But the house next to it, which is only 200 square feet larger, was valued at $110,650. Then he showed this slide of that house that we saw previously that was valued at $110,650. And then the house next to it was valued at $356,270. right? Which he also shows the correction after this error was brought up, they reduced it to $38,000, okay? But before this was brought up, the Jackson County government valued this specific property for $356,000. Then next to this house, the house was, and so this house is 1,036 square feet. It was valued at $70,050. Because remember, this house, right, is 960 square feet, but they valued it at 110. But you have this house that has more square footage, but they stated that this value was $70,000. Then the house next to that one, sorry, I'm just making sure. The house, then there's another house in that street that was worth $91,870. And then the house next to it was valued at $32,660. $32,660. And he basically shows these valuations to show that there were huge swings in the value from parcel to parcel. And he also stated that the $356,270 value that was placed on some of these parcels had a ripple effect in the neighborhood, because if in the system it states that one house is valued at such a high figure, then whatever mathematical calculations that they're using to value the entire neighborhood is going to be affected. That's what Preston Smith is alleging. Preston Smith stated that the data used from Tyler Technologies in Jackson County did not match with each other, and that it's clear that the two systems are not linked to each other. So in this testimony, Preston was basically talking about how he received data from both Tyler Technology and Jackson County, and he tried to link the data together. Usually there's key data, like some sort of ID, like an ID code that is shared by both systems so that they could be linked together, so he could use that data to analyze and see how the system is functioning, and if the Tyler data and the Jackson County data are actually, have a relationship to each other, which they should, because they're about the same. They're about the 2023 property tax assessments in Jackson County. But he stated that these two systems did not link with each other, which is a huge issue, because if the two data systems are not linking to each other, then how is the Jackson County Assessment Department supposed to be able to make sure that this data that Tyler Technologies is providing is correct? Preston Smith then testified that after he analyzed Tyler Technologies' data, that he found that there was a litany of errors. He stated that the data was improperly mixed, and he stated that the Jackson County's data was actually cleaner, and that Preston Smith actually helped Tyler Technologies clean up their own data. So next, Preston talked about information regarding this slide. So Preston Smith then testified about this pie chart. Preston Smith stated, and this is a pie chart that Preston Smith created. He stated that 81% of the parcels were inspected and 19% of the parcels were not inspected. Preston Smith then shows another chart of the 81%. And this chart here breaks down how these parcels were inspected. That there were some parcels that were, okay, so this is the breakdown here. So in this chart, it states that 66% of the property reportedly inspect. So I'm sorry, because I'm looking at my notes in this chart. So in this chart, it basically goes down to how these parcels were inspected, okay? Because if you remember in the prior trial, the state put on evidence stating that a physical inspection is a specific thing. It is not driving by and taking photos. It's when there's a field inspector that's measuring the property, and that there's a multitude of things that the inspector has to do in order to qualify as a physical inspection. And so in this pie chart, Preston Smith is actually breaking down how this is like what that was. And so Preston Smith's findings was that 66% of the property were inspected and photographed. So he's saying 66% of the property was inspected and photographed. Then he stated that 15% of the property was not inspected, but reportedly photographed. So he's stating that 15% were just photographed and no physical inspections occurred. Then he stated that 7% of the property had a physical inspection, but were not photographed. And 12% of the property was not inspected or photographed. Next, he talked about this slide right here. And in this slide, it basically states that 77% of the properties had an increase greater than 15%. 14% of the properties had an increase less than 15%, and 7% of the properties had a decrease in value, and 2% were new construction properties. Now, this is an important slide because in the 2023 property tax assessment, 77% of Jackson County parcels, and this is Preston Smith's testimony, their values were increased by over 15%. Now we're getting to the statutory argument that if a property value is increased by over 15%, a physical inspection is required. So Preston Smith is stating here that with more than 77% of the properties having an increased value in 15%, like this is showing that most of the properties needed a physical inspection to occur by the statute. But also another fact that we need to take notice of in Preston Smith's chart right here is when he stated that 2% of the properties were new construction properties. Now, if you remember in trial day 2, there was the he was the City of Independence city manager, and he was testifying about how if the new construction, if the 2023 property tax assessment was voided, that would hurt them because the new construction that occurred in 2023 would not be those parcels would not be valued correctly. And in this chart, it basically clearly shows that only 2% of the total 300,000 parcels in Jackson County were actually new construction. So the bulk of the harm did come from the residents. Next, Preston Smith basically showed this slide and stated that it would have been impossible for the county to do all the physical inspections. And so in this slide, it basically shows how much each inspector, how many parcels each inspector were inspecting per day. And he compiled this information and put it in a slide. And by using mathematics, he found that in order for the inspectors to complete the 2023 property tax assessment on time, to give physical inspections to all 300,000 parcels, that they had to inspect 38 parcels per day. But he stated that in 2021, they averaged 30 parcels per day, and in 2022, it was only 34. And so it was impossible for the county to have done physical inspections to all the parcels. Preston Smith then talked about the county's data regarding the photos that they used. Preston Smith stated that the time logs were off because the inspectors were able to close off time logs at different times. Now, this note that I took here is Preston was talking about how when the inspector would show up to a person's house and take pictures of the house, they were supposed to automatically upload those pictures to the data server, right? But Preston Smith stated by looking at the data, the time logs of when the picture was taken to when it was uploaded were off, because the inspectors would close their time logs at different times. So instead of uploading those pictures at the time that they were on the parcels, they would wait at different times. And so he stated that it was difficult to track the time logs. And he basically stated a specific example of a Tyler Technology employee uploading all of this data at 1:13 a.m. at his house, to show that it was virtually impossible to go back to the data of when a photo was taken to state, hey, this is the date and time the physical inspection occurred, because they were not uploading the photos or the information in a timely manner or in an instantaneous manner. Next, Preston Smith showed the cell data coverage from Tyler, and basically showed that there was no reason why time gaps should have existed, because Tyler Technologies had cell data coverage over the majority of the areas in Jackson County, and that therefore these uploads from these physical inspections should have been timely and instantaneous. Then Preston Smith looked at field inspector's notes, and he stated that the field inspector notes from Tyler Technology was not delivered fully to the county, and that only snippets were received. Hi, Paul Jones. Oh, yes. Thank you for the comment. So then Preston Smith looked at another exhibit that showed the geographical location of the data, and basically showed again that and so these, when he's showing these pictures, it's basically showing where the Tyler Technology employees were uploading the data to these servers. And he basically used these data points to show that they were uploading multiple data points, so multiple parcel physical inspection notes at different locations. And also, Preston Smith testified that he then compiled all this data together of the inspection time, and stated that the average inspection time that a field inspector had at a parcel was only 1 minute and 13 seconds per home. Preston Smith also showed data that showed that in one case, an upload of one parcel was made 20 miles away from the parcel that was inspected, basically showcasing again that these field inspectors were not uploading the data instantaneously. So Preston Smith made 5 findings, and his 5 findings were, and this is based on all the research that he did on Tyler Technologies data and on Jackson County's data. And his 5 findings were: 1, the data does not support that required physical inspections were completed, indicating problems with field inspection oversight and quality control. 2, the data does not support that the inspectors could have completed the required inspections, indicating problems with management control, field inspection oversight, and quality control. 3, that the data shows numerous calculation and assessment errors, indicating problems with quality control and management control. 4, the data showed dramatic unexplained differences in assessed values, indicating problems with quality control and management control. And 5, the data showed that inspectors' reports were inaccurate, indicating problems with oversight of field inspections and quality control. Preston Smith also testified to the errors in the appeal process. So what he's talking about is the appeal process with the BOE or with the State Tax Commission. And Preston Smith stated that he asked on multiple occasions from the county data to verify whether inspectors were there. The county refused to provide that data. So at this point, the state AG's office stopped the direct examination of Preston Smith, and the cross-examination of the county defendant started. So basically, when the county attorney's cross-examination started, they were basically trying to get information out of Preston that this is what Preston Smith admitted to, that he was not a licensed appraiser and that he was not an expert in the CAMAS system. And the CAMAS system is the, I believe CAMAS represents computer assisted mass appraisal system. I did do a video about this on the first video explaining the petition where it goes into the CAMAS system. And so he's basically saying, like, yes, I was not an expert in the systems that Tyler Technology were using at the time. Then Preston Smith also admitted that he did not provide a written report to the state AG's office about his findings because the state attorney general's office did not request one. Preston Smith also stated that the July report submitted by the county had less anomalies than the June report, which, when I think about that, it's like, yeah, because Preston was helped the county in June 1st to correct some of the massive errors in their first submitted values. So of course it had less anomalies in the June report had more anomalies in the July report. Preston Smith also stated that he emailed the county attorneys in June 2023 when he heard that the notices were going to be late that they were going to send the notices late. The county attorney responded that he wasn't an attorney and did not understand the law. Preston Smith talked about how he told people to appeal directly to the state tax commission and stated that he told people to appeal directly to the state tax commission because of the statute. The county attorney's office then focused on Preston Smith's emails with the state attorney general's office. Within the emails, Preston Smith stated that he provided people with a strategy to fight their property taxes. Preston Smith stated that he provided information to the attorney general to punish Frank White for dereliction of duty. Preston Smith also talked about Frank White and Gell's dereliction of duty. He stated that it surrounded the misrepresentations of the 2023 property tax assessment, coercing homeowners, and fraud. Plaintiff Smith then read the email that he sent the AG that stated all this stuff, and stated that he sent this email to the office in January. In this email, Preston Smith wrote that he did not believe a Clay County judge would understand the issues of the case and the process to get Frank White out of office for dereliction of duty. So at this time, I'm going to remind everyone, okay? First, with my opinion of the judge, I believe that the judge is being extremely fair in this case. She's 100% reasonable, and she's been handling every single hearing in this case as impartially as possible. I believe that she's well read, and she really takes the opinions of both sides, the facts, and the law into consideration before she issues her account. When Preston made these statements, he didn't know who the judge was, and so I say that because please do not send any communications to the judge. It will just it will not have the effect that you think it would have on this case. But also, the judge in this case is very qualified. And remember, Preston made these communications well before the judge was assigned to this case. Or I shouldn't say well before the judge was assigned to the case, but well before Preston knew who the judge was in this case. The email was also talking about, this was also crazy. The email that Preston Smith sent was talking about how they should threaten a Board of Equalization's attorney license to flip their decision. Preston Smith stated that these statements were made by another attorney and not him. Then the county attorney then referred to Preston Smith's slides. So the county attorney then was looking in on the $356,270 error. Preston Smith stated that he did not know how the $256,270 value was implemented into the CAMAS system. The county attorney is making the point that since he does not know how it was placed, he does not know whether it had the ripple effect. The county attorney then focused on one of Preston Smith's slides that had a typo that had a typo in it, where it said August 2023, not current. Or sorry, the slide said current when it should have said August 2023. The county attorney then asked who checked Preston Smith's work. Preston Smith responded that the county did and the county attorneys. When asked, so the county attorneys then asked why Preston Smith didn't allow other professionals to check his work. And Preston Smith stated that the data was confidential and he did not know if he was allowed to have peers check his findings. The county attorney states that to the judge that Preston Smith cannot testify, or sorry, the county attorney states to Preston that he cannot testify to the correctness of the data. But Preston Smith stated that when you are dealing with variances of the size of the error, that the variances were too large. Now, the reason why the county attorneys were stating this is because they were reestablishing that Preston is not an assessor, and he's never claimed to be an assessor, and so he cannot testify as to whether or not this data is correct. But Preston then stated that he's an expert witness on the data, and he's basically saying that the variances in the 2023 property tax assessment were too large in order to be correct. Preston Smith admitted that he did not have firsthand knowledge of when the notices were sent out. So then the county attorney's office looked, and they're still looking at the slides. They looked at the $47 million property slide. Preston Smith states that that was the value that he saw in June 2023, but it was changed in July 2023. And remember, going back to Preston's testimony, the reason why it was changed is because Preston alerted the Jackson County Assessor's Office of this error. The county attorney's office then made the argument that the values that Preston Smith were using on some of the properties were the initial values and not the certified values. Preston Smith then was looking at Gail McCain Beatty's testimony. So they brought up Gail McCain Beatty's testimony. The county attorney stated that Gail's property has increased since, now we have to remember, this is August 2023, okay, by 41%, okay? Preston Smith states that it did, but states that this change was after the certified assessment results. Preston Smith stated that this happened after the news report occurred. Now, during this time in August, I believe it was Angie Racono had a news report done that showed Frank White's properties increasing by 7% and Gail McCain Beatty's properties increasing by 13%. Now, when that news report aired, they then reassessed Gail McCain Beatty's property and increased it by 41% in August. But this, of course, again, was after the certified the certified values was sent by the Jackson County's assessor's office to the state Missouri office. Preston Smith also admitted to the county attorneys that he was campaigning for county executive, and he told the people that property taxes would increase by 45% in 2023, and that he was only off by 1%, as in the 2023 property tax assessment, property taxes were increased by on average 44%. Preston Smith then testified that when it came to Frank White's property, that it was a low increase in comparison to other properties in his neighborhood. The county attorney then made the argument that Preston Smith cannot state whether the values are correct or not because he is not an assessor. Preston Smith then stated that he is unaware whether these percentage changes of the properties are correct or incorrect because he's not an assessor. The county attorney then stated that then focused on the street that Preston Smith found and did an analysis on. And he stated that it was unlike Preston Smith to randomly pick a neighborhood with a $356, $270 error. But Preston Smith stated that 573 properties had this error. Preston Smith additionally stated that there was a 1% chance for him to pick this neighborhood randomly, but still that was the neighborhood that he picked. Preston Smith then testified that the standard deviation of the 2023 property tax assessment was too large. The county attorney stated that Preston Smith doesn't know the Canvas system, how to assess the properties, or whether the values were correct, and Preston Smith agreed. The county attorneys are now asking Preston Smith about his inability to get GPS data of the assessment. Preston Smith stated that he filed a Sunshine Law request and did not get the GPS data. Preston Smith states that the county told him that it did not exist. Currently, the county attorney is focusing, they're still focusing on Preston Smith's slides and how there are errors presented in the data by Preston Smith. Preston Smith stated that it was tough for him to get a full picture of what happened in 2023 because the data that Tyler Technologies gave him was not good. The county attorneys then started to drill a point that Preston Smith's data that he received had the possibility of being incomplete, and that the complete data exists elsewhere, but Preston Smith did not have it. Therefore, Preston Smith's data might be wrong. And as I stated before, I'm not going to give my opinion on this case until after the case rests. But I thought that this county attorney's argument was really interesting because usually during a trial, you have a period called discovery. And in discovery, both sides are supposed to turn over any requested evidence that is relevant to the case. And I'm pretty sure that the state attorney's office requested this data from the Jackson County government side. So I thought it was interesting that the county attorneys were drilling this point in because the data that was received by Preston from the Jackson County government through the act of discovery should have been the correct incomplete data. And for them to make that argument that it was not, for me, was very, very interesting. So, and I also made this note that they made this point, but the county attorney did not put on any evidence to support that Preston Smith did not have the complete data, and that they were just asking whether there's a possibility of this. And again, basically saying how weird it was for them to make the illusion that Preston Smith did not have the complete data, when with the rules of discovery, the Jackson County government should have given the complete data over to Preston or to the state AG's office when they made that request in discovery. The county attorney's office then asked Preston Smith about linking data tables together. Preston Smith stated that if the data tables cannot be linked together, it would create issues. This is going back to the testimony that Preston Smith was saying about how the county's data and the Tyler's Technologies data could not communicate with each other. The county attorneys are now implying that the data tables could have been linked together. And I made a note here that this has not been shown, but may be shown when the county defendants put on evidence. Preston Smith then stated that when the assessors came to physically inspect his home, that he told them to get off his lawn. Preston Smith stated that he did not want to assist the county in doing their job. So now the county attorney in this point of the trial are bringing up Preston Smith's Facebook post. And the county attorney is now asking Preston Smith's statements that he made on Facebook. One of the statements that he brought up was he viewed the Jackson County trial as D-Day, which is a World War II reference. The county attorneys are now handing, the county attorneys then handed Preston Smith an exhibit that were next door posts that he made. And in this exhibit, Preston Smith made statements about the judge in this post. When this post was read and the statements about the judge were read into record, I just want to state again, the judge was not entertaining this and asked for them to move on. And so this post that he made was not included into evidence. Preston Smith stated then that there are that there are at least 24,000 properties in Jackson County whose values increased by 15%, which had no evidence of a physical inspection. Preston Smith stated that if you included Tyler Technologies information, it would be over 51,000 properties. The judge then asked the county attorney, how much longer does he have? I'm going to explain this to you guys. So when the state attorney general's office or the state of Missouri called Preston to the stand, they spent an hour in order for Preston Smith to give his testimony. When during the cross-examination of the county defendants, Preston Smith was on the stand for over 4 hours, okay? And it was, for me as a viewer, it was a little bit taxing because there was some sense of delay in this because some of the questions that they were asking had pauses of like probably 1 to 2 minutes before they asked the next question. And of course, they were asking a lot of questions that really didn't go into whether or not Preston's data was correct, which is the crux of the county's argument right now. So at this point, the judge was probably also feeling that way too. So the judge asked the county attorneys how much longer did they have to how much longer that they needed to cross-examine Preston Smith, and the county attorney said 20 minutes. So then the county attorney's office continued, and they brought up Preston Smith's prior run of county executive, his prior lawsuits against Jackson County, which there's only one case that he had, and his prior meetings with the BOE. The county attorney then asked about Preston Smith's comments about the State Tax Commission. Preston Smith stated that the State Tax Commission had the power and authority to fix the assessments, but that they did not. And he stated that he thought that the State Tax Commission in 2019 was worthless. So these are all referring to 2019. The county attorney then handed Preston Smith an exhibit of a post that he made on the Fight Jackson County assessment page on Facebook. And in this post, Preston Smith is stating that he believed that the State Tax Commission was worthless, lazy, and could be a part of the deep state of Missouri. And in this post, he's referring to the State Tax Commission in 2019. Preston Smith's post also refers to unelected bureaucrats. Preston Smith stated that he thought the judge in 2019 was corrupt because the case was thrown out without any evidence being heard. Preston Smith is clarifying what he meant by deep state. He stated that the deep state is unelected bureaucrats. The county attorney asked whether the State Tax Commission is a part of the deep state. Preston Smith stated that he believed that in 2019 they were. The county attorney now asked Preston Smith about his beliefs on Black Rock. The state attorney general basically then objected to relevancy and harassment and basically stated that they're trying to delay the time. The county attorney argued that this is relevant to bias. The judge then stated that she's allowing this, but is noting that they're going to shaky ground and that they've been doing so for over an hour. The county attorney is now asking Preston Smith about his contacts with Sean Smith, And basically it wasn't anything. And so at that point, the county then stopped their cross-examination. The state AG's office then came back for redirect, which redirect is that the state AG's now can ask questions in order for Preston to clarify his prior testimony. So, at the beginning of the at the beginning of Preston Smith's testimony, when he was going over his work history, he mentioned that he worked at DST, but then was fired from DST, and the county attorneys never gave him a chance to explain why he was fired. And so the state AG asked Preston to clarify why he was fired from DST, and Preston Smith basically said that he accidentally received an email that disclosed all the salaries at DST, and he realized that his female counterparts were being paid half of his salary. Preston Smith sent the email to those female employees. Those female employees then contacted DST and requested that their salaries should be the same as Preston's. DST asked the female employees how they received the information of Preston Smith's salary, and they disclosed that Preston Smith sent it to them. When DST asked Preston Smith, he stated that he did send it to them and requested DST to pay them the same salary as they paid him. DST then fired Preston Smith for sending the information to the female employees. When Preston Smith was leaving the DST offices, he requested that the female employees should file a complaint with the EEOC for discrimination. So after he stated this, Preston Smith was excused from the stand, and then Gail McCain Beatty came to the stand. And I have to tell you, at this moment in trial, when Gail McCain Beatty came to the stand, the whole courtroom went quiet, okay? And that because people have been anticipating Gail McCain Beatty's testimony about these issues of the 2023 property tax assessment for the longest time. And at this time, she was finally coming to the stand. So the state AG's office called Gail McCain Beatty to the stand. And Gail McCain Beatty is our current county assessor, and she has been our assessor for over 7 years. Gail McCain Beatty stated that she understood that she was supposed to comply with state and county laws and ordinances. Gail McCain Beatty stated that a physical inspection was completed on all properties. Now, this is a direct statement from Gail McCain Beatty. She stated that a physical inspection was completed on all properties. Now, remember, in trial 1, 2, and in Preston's testimony, they're basically stating that at least 20% of parcels in Jackson County did not have a physical inspection done. And Gail McCain Beatty is stating that no, that was a lie. A physical inspection was completed on all properties. Gail McCain Beatty stated that she didn't recall whether she questioned Tyler's ability to complete the inspection on time. Now, at this point, the state attorney general's office then stated to the court, "I would like to play Exhibit 47.1. And at this time, I thought it was a video deposition, right? As I told you before, a deposition is when a person can ask the other person questions of any kind and they make commentary on that. But it was not a video deposition. These were actual video Zoom call like conversations, calls that she had with Tyler Technology in 2020, 2021, 2022, and 2023 that for some reason they recorded and the state AG's office had, okay, which this surprised me, okay? So they're playing these recordings that she had, which usually you would think that these are private conversations, but these were actual Like this was the actual video call that she was having with Tyler Technology in the in 2021, 2022, and 2023. So in this specific video, Gail McCain Beatty is discussing with Tyler Technologies as to whether the assessment could be completed in time. And Tyler Technology said that the best case scenario would be that the assessment would be completed in December of 2022. So that's like at the last minute. Gail McCain Beatty stated that Tyler staff then did the reassessment and not the Jackson County Assessment's Office. Gail McCain Beatty stated that the data delivered to her in 2023 was from Tyler Technologies and not from the people working in her assessment department, which is an important point to note. Gail McCain Beatty stated that she did not provide written notice of the increases before the physical inspection, which, if you remember in my previous videos on this, the state AG's argument is that the Jackson County government did not follow the statutory process of notice when it came to these property tax increases, because when a parcel's value is increased, and this is their assessed value, is increased by over 15%, they are required to first send a notice out to that parcel owner of that 15% increase, right? And when they send out that increase or that notice, it's supposed to notify them that their parcel is going to be increased by over 15% and that they have a right to an interior and physical inspection. So after that notice is sent out, then they're supposed to conduct that physical inspection. So as I stated before, there's first a parcel by parcel review. Then the properties that they think are going to increase by over 15% value, a notice is supposed to be sent out to those properties. Then, and that notice is supposed to say that you have a right to a physical inspection and an interior inspection. And then the physical inspection is supposed to occur. And then afterwards, you get that official 2023 reassessment notice. Right here, Gail McCain Beatty is admitting that she did not provide written notice of the increases before the physical inspection. Next, Gail McCain Beatty stated that she did public meetings, media, and print instead of giving written notices because there were interference with the physical inspections. And she gave examples saying that there were people telling assessors to get off their property and putting their lives at risk. Gail McCain Beatty then stated that that by law, she has to give a physical inspection if the property's assessed values increased by over 15%. Then they can request an interior inspection. And then Gail McCain Beatty stated that she complied with this law. So in Gail McCain Beatty's mind is that she didn't have to give notice first before the physical inspection. She basically stated that she can have the physical inspection, then provide notice. And in that notice states that an interior inspection is required, which that's not what the state has stated is the correct way. Gail McCain Beatty then stated that if the property owner completed a questionnaire, then they would, okay, so I have to go back. The state attorneys then handed Gail McCain Beatty the Missouri State Auditor's report that had basically the notices, the 2023 reassessment notice, and the door hanger notice in that exhibit. And they asked Gail McCain Beatty to look at the door hanger. So they're specifically talking about the door hanger right now. And Gail McCain Beatty basically say that if the property owner completed a questionnaire, and the questionnaire is those door hangers, okay, that then they would not have to receive that notice, okay? So she's saying that if the property owner completed the door hanger, they weren't statutorily obligated to provide them with the notice. But if the physical inspection was completed while the property owner was there, then they would then they would not receive a written notice. So they're basically saying that if the property owner either completed the door hanger, or if when the Tyler Technologies people came to the door and the owner was there to complete that questionnaire, that the Jackson County government did not have an obligation to provide them with a notice that their property assessed values would be increased by over 15%, right? Which the state AG's office is arguing the other way, that they had to provide the notice of the property owners notice that their assessed values were going to be increased by over 15% first, then provide them with a physical inspection. But Gail McCain Beatty stated that she didn't have to do that. Then she admits that the written notice that she gave to Jackson County property owners was the door hanger. Gail McCain Beatty stated that she mailed a notice to every property owner in Jackson County. And when I heard this, my mouth dropped, because I didn't receive a notice. And the notice that she's talking about isn't the 2023 reassessment notice. What she's talking about is the notice that's statutorily required for properties whose value increased by over 15%. So the first notice that we were supposed to receive. And she stated that this was sent out to everyone. Gail McCain Beatty then stated that for an exterior physical inspection, there must be a person on the premises, and that there must be a measurement taken and a photo taken. So she basically is acknowledging that for physical inspection like a valid physical inspection needs to have measurements taken, the person to be there for a length of time, and a photo to be taken. Gail McCain Beatty then basically, the county attorneys, or sorry, not the county attorneys, this Missouri State Attorney General's office then asked Gail McCain Beatty, are you supposed to measure the entire house? And Gail McCain Beatty stated that if there was a perfectly rectangular home, then they would only have to measure one side. But if the house is not perfectly rectangular, then the field officers are supposed to measure every single side. Gail McCain Beatty then stated that there were instances that Tyler Technologies would not measure the entire house, and that's when they did not have access to the home. Like, for instance, if the property owner had a fence or was blocked access to the home. At this point, the state attorney general's office is asking Gail McCain Beatty to look at the Jackson County ordinance on the physical interior inspections. Gail McCain Beatty then read the ordinance, and Gail McCain Beatty stated that she believed her assessment department completely complied with this ordinance. The state then directed Gail McCain Beatty to the ordinance, and the ordinance that they're citing is 2002.4 subsection B. And it states in this ordinance that the notice, so when they're talking about the notice, they're talking about the notice that we were supposed to receive, that a physical inspection needed to happen because our property values were going to increase by over 15%. And that this notice was supposed to include the name, date, time, and extent of the exterior inspection. The state AG's office is asking whether this was included. So they're pointing to this Jackson County ordinance, okay, and they're asking Gail McCain Beatty if this was included. Gail McCain Beatty states that she believes that the date and time was on it, but that they did not put the name on their notice because it became a safety issue. She stated that guns were drawn on her staff, people were attacked by residents, and that there were other unsafe situations that happened with the field inspectors. Gail McCain Beatty stated, then Gail McCain Beatty said on stand that she did not comply with the notice section of the ordinance. Gail McCain Beatty stated that the mailed notice did not have the name, date, time, and extent of physical exterior inspection on it, which, that's a complete violation. Gail McCain Beatty then looked at the preliminary letter sent by the auditor's office. So if you remember, in my trial day 1 and day 2 video, we went over the auditor's office testimony, and it was the preliminary letter that the state auditor wrote, basically saying that the property tax assessment did not comply with state statute. So she's looking at that letter. The state attorney's general office also gave Gail McCain Beatty an example of the written notices and the impact notices. So the first notice that was supposed to be sent out and the impact notice that was supposed to be sent out that she gave to the auditor's office. Gail McCain Beatty stated that these were the notices that were sent out to the Jackson County residents. Gail McCain Beatty stated that she did not send out property cards or comparables to the residents. The state attorney general's office then asked Gail McCain Beatty where on the notice it states that the residents have a right to a physical inspection and an interior inspection. Gail McCain Beatty stated that the section is on the notice. And so at this point, the state AG asked her to point that out. And she points it out, and the state AG's like, does it say a right to an interior? And she's like, no, it does not say a right to an interior inspection. The state AG's office then asked where on the notice it states that residents have a right to a physical and interior inspection. Gail McCain Beatty stated that the right was inferred in the notice, okay? So she's basically saying that it wasn't stated, it was inferred. The state AG office then asked Gail McCain Beatty how the property owners could have known that, how they could infer this from the notice. Gail McCain Beatty then stated that that they would just know, and that the notice that the Jackson County government was sufficient. The state attorney general's office then asked about the 30-day notice. So as a state attorney general's office has argued before, there must the Jackson County government was required to provide a 30-day notice, or was provided to give Jackson County residents a 30-day notice of an interior inspection by state statute. Gail McCain Beatty stated that this was not on the notice, but that they gave residents more than 30 days to have the interior inspection. Gail McCain Beatty stated her notice differentiates between an exterior and interior inspection, and that they are different. However, Gail McCain Beatty basically stated that they are both physical inspections. So at this time, she basically states that she knows that a physical exterior inspection is different from a physical interior inspection, but basically stated that even though she knows this, she still regards them as both a physical inspection. Take that as you will. Gail McCain Beatty then stated that an interior inspection, that when performing an interior inspection, that the county is only able to see what the property owners show the assessment department. Gail McCain Beatty admits again that the notice does not state a right to interior inspection. So she admitted that. Gail McCain Beatty then stated that her office so she stated that she knew that her office cannot do drive-by inspections and quantify that as a physical inspection. Gail McCain Beatty stated that the notices were not deficient, even though she admits that the notices did not have the name, date, and time and extent on the notices. Gail McCain Beatty then stated that the door hangers were sufficient and that people responded. The state attorney general's office then went back to the door hanger and is asking the question again as to whether the door hanger notice complied with state law. And what I'm about to tell you, when I do this is a direct quote. Gail McCain Beatty stated that it complies with the spirit of the law, but then admits that it does not have the information on the notices. Okay. Now, she basically here is admitting that it did not comply with the letter of the law, but but she stated that it complied with the spirit of the law. And when she said this, I was very shocked when she said this, like the spirit of the law. Anyways, and that's a direct quote from her. The state then asked where the date, name, and time was included on the door hangers, because remember, she stated that this information was there. Gail McCain Beatty stated that the assessors had to write in that information. The AG office then stated that there's no space provided on the door hanger for that information to be included. Gail McCain Beatty stated that there was space. They could have wrote it on the top. And let me actually see if I have this still on here. Yes, here. Hold on a second. This is the auditor's report, folks. This is the door hanger, okay? So what Gail McCain Beatty is basically stating is, you see because she's pointing to the blank space by the hole on this door hanger, and she's stating that the inspector could have just wrote the information on that blank space, which for me, that's wild. Gail McCain Beatty then stated that she cannot guarantee that the assessors included that information on every door hanger. Gail McCain Beatty then stated that she could not guarantee that any assessor included that information. Okay, so she not only stated that she can't guarantee that every door hanger had that information, but she can't guarantee that one assessor in the 300,000 parcels included that information on that door hanger. Gail McCain Beatty then stated that her staff drafted the notice letters. So we're referring to this one here. Gail McCain Beatty states that the notice letters did not go out to every property owner, okay? And this is a reminder. These are the notice letters that the state is arguing that that the county assessor has a statutory obligation to send out to every single property owner whose assessed value increased by over 15%. And in that letter, it's supposed to, 1, indicate the assessed values increase, 2, that they had a right to a physical inspection, 3, that they had a right to an interior inspection within 30 days, okay? And here, Gail McCain Beatty is admitting that this letter right here was not sent out to every single Jackson County resident. And remember, again, that this letter had to be first received by the property owner whose assessed value increased by over 15%, and then the physical inspection was supposed to happen. That's the state's argument as to what the statute requires. And Gail McCain Beatty is admitted that this letter that the notice that they sent out to the Jackson County residents whose property values increased by over 15% happened after the physical inspection occurred. Gail McCain Beatty then stated that the notice letters were sent out in April, and the impact, which I'm going to go here, this is the impact letters, okay? And that the impact letters were sent out in May and June. Gail McCain Beatty then stated that she knew that the interior inspections would be required by law if requested. Gail McCain stated that before the first notices went out, she did not know whether the property assessed value would increase by over 15%, okay? Now, when she's talking about first notices, she's talking about this, okay? So she's admitting that when they hung these door hangers here, that her office didn't know whether that parcel's value was going to increase by over 15%, right? So we have to think about this in the grand scheme, right? Under the state statute, a Jackson County's resident who has a property's assessed value increased by over 15%, they are first supposed to receive notice of the assessed value increase. And then the physical inspection is supposed to happen. Gail McCain Beatty, at the beginning of her testimony, basically stated that this door hanger was the notice that she was statutorily obligated to give to the Jackson County residents, but then admits that when these door hangers were being hung on people's doors, that she did not have the information as to whether that specific property's value was going to be increased by, or their assessed value was going to be increased by over 15%. Gail McCain Beatty basically stated that that she had this information in the beginning of January 2023 as to what property owners or what parcels were going to have their increased value increased by over 15%. Gail McCain Beatty stated, okay, so then they showed another video, okay? And this is another video call between Gail McCain Beatty and Tyler Technologies. And Gail McCain Beatty stated in this video that it would be difficult to accomplish the interior inspections if the notices were received too late. So she's admitting, and so this video, I believe, don't quote me on this, but I believe this video was taken in January 2023, but don't quote me on this. But she's basically admitting that, yeah, they were supposed to provide property owners who had their assessed value increased by over 15% more time than more notice time. So we received, the majority of the Jackson County property owners who had their assessed value increased by over 15% received notices of those increased values in June. Okay. She states in this video that she knew that they were supposed to receive more time in order to finish the interior inspection before the reassessment notice. And remember, this is the reassessment notice, okay? But of course it didn't happen. Gail McCain Beatty, and this is in the video, stated that she anticipated the drastic increases in property values. Gail McCain Beatty stated in this video, so they're showing a multitude of videos. So then she stated that in 2022, so this video was in 2022, that she knew that a number of properties would have their assessed value increased by over 200% and that over 10,000 appeals would be filed. The state then shows a video of her stating this. Gail McCain Beatty states that they were anticipating, and so this is a video in 2002, okay? Gail McCain Beatty is stating that they're anticipating over 40,000 appeals and that she believes that they, and when they say they, she means her county assessment department, are not increasing the properties as much as they should have. Gail McCain Beatty then stated that after the video was played, which shocked me because she wants to increase our property values even more. Okay, that's what she's admitting in this video. After the video concluded, Gail McCain Beatty then stated that some of the words that she used in this video were incorrect. Gail McCain Beatty stated that she Gail McCain Beatty then stated that she wanted to resolve as many appeals as possible before it goes to the BOE because the BOE is notoriously slow. Gail McCain Beatty then stated that the process of going to the BOE was worsened because of misinformation. Gail McCain Beatty stated that the Jackson County legislature was holding meetings and not providing true information to the public. Gail McCain Beatty stated that people would take over her meetings and put up billboards and do a lot of other things in order to spread misinformation. Gail McCain Beatty then stated that there was unprecedented public interference and that this hurt her assessment process. Gail McCain Beatty then continued and stated that she needed security at her meetings, that she even hired a PR team to ensure that correct information was getting out to the public. And that then they go into Frank White's increase of 7%. And she stated that she was aware that Frank White's home was increased by 7%, but she didn't have any information about the Blue Springs Mayor Ross's home's decrease in value. Gail McCain Beatty then stated that the auditor's office has not concluded that she has violated state law because the final report has not been issued. So she's saying that even though we have this preliminary report from the state auditor's office that states that the Jackson County Assessor's Office, their assessment of the 2023 property tax assessments violated the state statutes. She's stating that that is actually incorrect to assume that because the final report hasn't been issued. Gail McCain Beatty then admitted that the preliminary report did conclude that they violated state law. Gail McCain Beatty then stated that the auditor's report misinterpreted the law. Gail McCain Beatty stated that the auditor's requirements are impossible and that she disagrees with them. Gail McCain Beatty then stated that she did not know what she's going to change for the future assessments until the final report is issued. Gail McCain Beatty states that she will not follow the preliminary report. And I state this because remember, in 2025, we have another reassessment, okay? We have another assessment, and it is now July 14th, 2024, and we have the county assessor basically saying that even though they received this preliminary report, basically giving them notice of all the state statutes requirements that they are not following in order to conduct a legal assessment, that they're not going to follow that preliminary report until the final report is received. And remember, in 2025, they have to have those the assessments have to be done by 2024, right? So for me, that was wild. Gail McCain Beatty stated that the state tax commission has not told her did not tell her anything about how she violated the law. And Gail McCain Beatty admits that she read the petition and that it states that she violated the law. Because remember, the other there are two parties that are the petition that are the plaintiffs. It's the state of Missouri, represented through the state attorney general's office, and it's the Missouri State Tax Commission as the other plaintiff. Gail McCain Beatty stated that until she heard the lawsuit, that she did not know of any concerns that the state tax commission had. Gail McCain Beatty stated that all communications with the state tax commission were positive and did not tell her anything that she was doing wrong. Gail McCain Beatty then stated that the Jackson County legislature would do anything to throw out this assessment and that none of them are qualified to have that opinion. Gail McCain Beatty admitted that Blue Springs and Independence and the Board of Equalization told her that they believed that she was violating the state statute and their codes and laws. Then the state attorney general's office presents Gail McCain Beatty a letter from the Board of Equalization. And in the letter, it stated that the assessor was attempting to circumvent the process and violate the codes. Gail McCain Beatty stated in response to this letter that she did not agree with the letter from the BOE, from the Board of Equalization. There was a part here where the state was asking Gail McCain Beatty about her interpretation of Mayor Quentin Lucas's statements about the property tax assessment, but objections were made and the judge agreed that the statements were irrelevant to the case. But Gail McCain Beatty stated that the mayor made a comment to her about the property tax assessment, but she does not recall the statements that he made to her about it. And at that point, the judge called the trial date to the end and made a ruling that the court was going to continue the trial to August the 9th. So at this point, Gail McCain Beatty is still a sworn witness on the stand, and she will return to the stand on August 9th. And at this point, I'm actually done going through the notes that I took of the witness testimonies. So if anybody has any questions about the witness testimonies, please type a comment in the chat right now for me to respond to if you have questions about the presentation and the information that I provided. Otherwise, I'm going to log off, and I wish everyone to have a great evening. But if anybody has any questions that they want me to respond to right now, this is the best time for you to ask. And also, sorry about my video, like the internet speed. It's a little bit blotchy. Okay, oh, thank you, Claire. And also thank you, Paul Jones. I saw your comment earlier. Thank you so much for your compliment. So Paige Walcott asked, regards to the possible professional misconduct between the AG. So basically, what the judge ruled in the motion for sanctions hearing is that there could potentially have been an attorney-client privilege violation between the communications that Sean Smith made to Andrew Bailey. And so she allowed, the judge allowed the deposition of Andrew Bailey in order to ensure that no attorney-client privilege information was disclosed to him during those meetings. The judge, I believe, has already made a ruling that with regards to the communications made to the state attorney general's specific attorneys, that no attorney-client privilege information was disclosed, but that's why she ordered the deposition. If it's found that attorney-client privilege information was disclosed to the Missouri State Attorney General, Andrew Bailey, then it would then be on the judge to decide what sanction needs to be made on this case. But right now it's in the stage of you have to depose Andrew Bailey first to see if an attorney-client privilege information was disclosed or not. Thank you, Keith, for the compliment, and also thank you, Caroline, as well too. And if anybody, if nobody else has any questions about this presentation, then that's basically it for today's Let's Talk Jackson. As I stated before, there's going to be a Let's Talk Jackson regarding the August 9th trial on that following Sunday. But on August 9th, I will also be live tweeting updates from that trial on my Twitter page, which is also at Stacy Lake MO. So if you're interested in receiving live trial updates, please follow my Twitter page. And on August 9th, I will be providing that. Now, on August 9th, Gail McCain Beatty is going to be returned to the stand. Like, she's still a sworn witness, okay? And I believe that's going to be the last witness that the state attorney general's office has for their case. So, and when I'm talking about the state attorney general's office, I'm talking about the state of Missouri and the state tax commission. And so after Gail McCain Beatty leaves the stand, I believe that the state's going to rest their case, and then the Jackson County government defense is going to happen on that day. So is August 9th going to be the last day of trial? I don't know. I don't know how long Gail McCain Beatty is going to be on the stand, and I don't know how many witnesses Jackson County government has in order to provide a defense. Thank you, Ned, and thank you again, Paige. With that said, I will see you guys. Hold on a minute. I will see you guys. Okay, so August 9th is Friday. Just FYI, right? So I will have my next Let's Talk Jackson live on August 11th. And I will see you then. And if you can, please share this video because right now there's no media sources that are covering the Jackson County trial, which for me is ridiculous because historically speaking, this is the largest trial or case the Jackson County government has ever had. This implicates every single property owner in Jackson County, and the people need to be informed about what's going on because there's a potential that the judge might void the 2023 property tax assessments that would affect every single parcel in Jackson County. So please, if you can, share this video. Share this video with everyone that you can in order to spread the information what's going on in trial. And I hope you guys have a good rest of the day. Ned asked, my assessed market value was increased by 250% and my property tax increased by $1,200. Any hope for me? I mean, honestly, Ned, look, I don't know. Because at the end of the day, so the judge, if the judge makes a finding that the Jackson County government violated the state statutes and the codes and the ordinances and conducted an improper assessment in their 2023 property tax assessment, one of the remedies is that the judge could order that the 2023 property tax assessment would be completely voided. And what that means is that they would use the 2022 values in order to dictate what your property value should have been in 2023, right? If that happens, then yes, it will be rolled back. But again, the judge might not find that way or might make a ruling that remedy avoiding the 2023 property tax assessment would be too severe and therefore would cause more harm than remedy and might suggest another remedy. And also for my audience, this case is most likely going to be appealed and is most likely going to go all the way up to the Supreme Court. So no matter what the judge's decision on this, it will be appealed. It will be analyzed by not only our Western District Court of Appeals, but also probably the state of Missouri. So I hope I answered your question, Ned. Anyways, with that said, that concludes today's Let's Talk Jackson. And I hope you guys have a good rest of the day. See you. Bye-bye.